Good evening, ladies and gentlemen. It is so nice to be back here for 2022's first expert advice webinar, and welcome to everyone who is on this webinar this evening. If you could just let me know in the chat box, can you hear me? Can you see me? We just had a small issue with the video we wanted to play, but let me know in the chat box. Introduce yourself if you're new here. Let me know where you're from. What's your name? Can you guys hear and see me? That's the most important thing. There we go. Carl says loud and clear. Thanks, Carl. Chanel. Hello, Chanel Boyson. Nice to see you online from Midrand. That's great to see. Obviously from all over the country. I see you got a good turnout this evening, ladies and gents. So thank you so much for that. We've got Kerry from Pietermaritzburg. We've got Diane from Springs. I see Mr. Walker himself is online as well. Hi, Jack. Good to see you. Everyone can hear me. Tumaleng. Hello, how are you doing? One of my students, that's great stuff. Simpiwe, Tanya, welcome from Cape Town. Melissa, Millicent from Pretoria, I hope I'm saying that right. Great stuff, guys. So I'm super excited to be here, ladies and gentlemen. As I said, this is the first expert advice series or webinar for 2022. And this year, we are going back to in-person events. We've already had a networking event in person. Our wealth builders are going to be in person, and that's super exciting. I think this whole COVID thing is hopefully slowly but surely just passing by, so we can get back to normal life. Dave is here in the background. Nalfi, welcome to you from Midrand. That is awesome, ladies and gents. Now, tonight is going to be very, very interesting. The Property Practitioners Act is a very important piece of legislation that we need to know as property investors. So I'm super excited to introduce our guests this evening and know all about it. I can just get my clicker to work, then we will get going. Doesn't want to work. Okay, so ladies and gents, who are we? For those of you who are new with SAPN, if you just joined, this is the very first webinar. It was started back in 2013 by Andrew Walker, who is online. And Andrew just had this vision when he came back from the UK to start a network of like-minded individuals specifically focused on property investing and building wealth through property. Because one thing Andrew realized in his journey or while he was in the UK is that your network is probably one of the most important things that determines your success as an investor. You've got to be speaking to like-minded individuals. And he started SAPN back then, and we've really grown into an amazing company and the biggest property network in the whole of South Africa. I think we're about 60 or 70,000 members strong, or at least on our Facebook page. So that is really, really cool, ladies and gents. And we're all around the country, all the major metropoles in South Africa, and reaching to the smaller places. We even got East London on board. Can you believe it? I'm based in PE, so the smaller places as well. Now we've got different memberships, from free membership all the way up to professional memberships. And please go have a look at our website, joinsapn.com/membership, and go check out what all you get in our memberships. Really some amazing tools that you need to be successful in property investing. I'd just like to thank our partner, Absa Bank, the big boy bank. Thanks for partnering with us and really providing such great insights from your guys' perspective. And then also to all the sponsors. Thank you to you guys. Without our sponsors and our partner and our associates, ladies and gents, we won't be able to be here with you. So really, really, these guys make your journey as a property investor a lot easier. That is for sure. So for those of you who haven't met me, my name is Jade Barcase, and I'm from Port Elizabeth, the Windy City. I'm full-time in property. Property is really just my passion. I'm a commercial property broker or an estate agent focused on commercial real estate. I also invest in property. So I've got student accommodation, done some installment sales, I've done flipping, so a few different strategies. And I love to partner with investors on my deals and love just meeting new people. And that's why I get so excited when I see these new faces joining our webinars. But that's enough about me. Let's get on to the good stuff, the reason why you joined, ladies and gents. We will get to our guest speakers in just a second. So please check out your inbox. If you're on our database, you will receive our emails. Please check your spam. Make sure it doesn't go into your junk or your spam folder. Please go like us, follow us on LinkedIn and on Facebook to see which events are coming up. the next event might just be the one that you need. Now, as I said, this evening is all about the Property Practitioners Act, which is extremely important, ladies and gents, for property investors. I hope you're not one of those people that say, well, I'll just go on with my business and sort of put my head in the sand. Unfortunately, this applies to so many people in our industry, and I think it's great to have this webinar. So I'm going to bring on our guest speakers for this evening. They are experts in the legal field, and that's what we bring to you at SAPN, is really the experts to talk about the different topics. So Bruno and Peter, welcome, guys.
Hey, Jade.
Hi, Jade.
Good to see you guys online. I think I'll just give over to you. We can get going. Bruno, I think you can start us off. We're not sharing any slides. We're just going to have a chat about the new act. So take it away, Bruno.
Sure. Oh, absolutely. So most of you know me, so I'm not going to introduce myself. I don't know, Peter, do you want to maybe just do a quick introduction so people know who you are, what you're about, and your involvement with the PPA?
Thank you very much, Bruno. Before I get going, everybody, I apologize for my background and everything that's going on tonight. It is the first time that we don't have power in my house. And unfortunately, my Wi-Fi is off and everything's gone to somewhere else this evening. So I do apologize for how I'm coming across this evening. Hopefully you can all see me, hopefully you can all hear me, but it looks okay for the moment. If it does tend to get a little bit staggered, Bruno, Jade, would you just please let me know? And I'm just going to put my video off so that it doesn't take up much of the bandwidth. My name is Peter Menon. I'm the head of legal for TPN Credit Bureau. If you don't know TPN is a credit bureau in South Africa, specifically focusing on the property market. We've got a niche data set that includes how tenants. Thank you very much, Dave. Cheers. We've got a unique data set in that we capture payment profile information on how tenants pay both their residential as well as commercial rentals in the country, as well as how parents pay school fees and how owners pay levies in complexes. So quite an interesting business, a lot of big data coming through the business. But like I said, we do provide for free training through our YouTube site as well on legislation changes, things that occur in the marketplace that you might be interested in. But Jade, just like what you said, that's enough about me, Bruno. I think we can get going on this PPA thing, hey?
Cool. Awesome.
If I can just quickly jump in there, sorry, Bruno and Peter. I just want to introduce Shitty Boy as well. Or Shitty Boy, you can also introduce yourself. Apologies for that. I didn't realize you're on it. And then, ladies and gents, please, if you've got any questions, please pop them in the Q&A tab, not in the chat box, in the Q&A tab. At the end of the webinar, we will be answering those questions. So please go ahead and do that. Thank you. Over to you, Bruno.
Sure. Shitty Boy, are you there?
Hi, Bruno. Sorry. Yes.
Quick intro, or you good?
Yeah, no, look, I don't mind. Let me just bring the screen back and yeah. Oh, the host must allow my video to start if they don't mind. So yeah, my name is Shili Boy. I'm a co-founder of Intergen. Intergen is wealth preservation private company. We use both tax and legal principles to instill some form of discipline within property investors on preservation of wealth. So I'm very interested to share a snippet of what we found PPA to be more relevant to property investors, especially when it comes to an element of accounting records and also a bit of tax compliance, because it's one of those prerequisites that for a property practitioner to actually be eligible to register with authority to be needs to have tax certificate. Bruno?
Sure, cool. So maybe just to start off with, we go right to the beginning where we explore who the act is covered by. So what is the definition of property practitioner? Who would be required or rather regulated by the act? maybe even before going there, I think it is important maybe to touch on the purpose of the Act. I know that Peter has also touched on this quite a bit. From my side, the way that I've seen this Act is there had to be a lot of refreshment when it came to the state agency field or industry. The acts were outdated. Most things were outdated. Even the functioning, unfortunately, of the board, the State Agency Affairs Board, it was outdated, wasn't optimized. So this act was almost an injection into the industry to try and revitalize the industry. Unfortunately, and this is my personal opinion, the act was drafted with estate agents in mind. The wording, everything about the act almost smells, tastes like they're trying to govern estate agents. And then the catch-all provision of what a property practitioner is then all of a sudden thrown in there. And I think that's what's caused the major confusion when it comes to the implementation of the act. Most estate agents are actually good. There's small little things here and there. How do I register? When do I register? What are the transitional provisions? How do I market? What do I include in marketing material? But those are just like little details. Those are things you can very easily kind of move through or maneuver through. The difficulty is the questions I'm getting from, and we'll touch on this later, property developers, home inspectors, bond originators, investors, so owner investors. I mean, I'm even getting questions around curators that aren't attorneys. Management companies. So I mean, this is something Shilly Boy deals with all the time. We structure a lot of tax affairs by having a management company that manages the property on behalf of somebody else and gets a fee for it. And this is all tax planning. And now with this, you're required to be registered as a property practitioner. So there's a couple of examples like that. So Peter, over to you. As far as purpose is concerned, what are your thoughts?
Thanks, Bruno. I think, there's two discussions, obviously, within when it comes to the purpose and when it comes to the definition of a property practitioner. I mean, the definition at the end of the day has been broadened so much that, like you said, we're getting these incredibly difficult queries through from, should we be registering through the Property Practitioners Regulatory Authority as a property practitioner because we do certain things as we've always done, like supervision or management or the administration of properties. The definition is so far wide or so far ranging that, I mean, in certain contexts, it could include, like you said, your clients who could be perhaps developing properties and those parties who manage those properties on their behalf, which wouldn't have previously been included in the Estate Agency Affairs Act. Bruno and I did have a conversation about this beforehand. I just want to let you know, just so that we get on the same page. But at the end of the day, the difficulty behind saying who's going to be impacted and who's not going to be impacted is sort of a semantics argument. I mean, you can read very, very clearly into the definitions what they've tried to include. They've tried to include people like bond brokers, even though they are excluded in a certain way if the definition falls under the Financial Sector Regulatory Act. Thank you very much, David. I saw I was staggering there. Not staggering in speech, but staggering in the video. And I mean, that includes a far-ranging aspect where you've had this regulation, or rather the definition that didn't necessarily or wasn't supposed to apply to people that other piece of legislation already includes. So it is a very difficult conversation of who it's going to impact and who it's not going to impact. What I can say from a 100% perspective on this is that all estate agents, obviously commercial brokerages, possibly property inspectors, property valuers would be included in that definition. But also I've read so many opinion pieces now on this. The latest one that I read was from a director at Cliff Decker Hofmeyer regarding investors specifically and property developers, and how he argues that developers shouldn't actually be included in this and the people that manage their properties. So it is going to become a very interesting topic in the next couple of months. I think we're going to see quite a lot of litigation on this, or rather exclusions that people are trying to apply for through the Property Practitioners Regulatory Authority. I'm going to try to be as diplomatic here as possible, but it's almost, it's possible, but very impossible to contact them at the moment. I have clients trying to email them 10 times a day, asking if they should register or if they shouldn't register, but we're probably going to see a directive in the next couple of months regarding who's supposed to do what and who's not supposed to do what. Looking at the perspective, or rather the purpose on your first question, I think it's important to note that Bruno said something very, very apparent here. The legislation is pretty old when you're dealing with the Estate Agency Affairs Act. It's an outdated piece of legislation that needed to be updated. And through this update, there's a number of different purpose provisions that they've sort of included. It obviously regulates property practitioners. It applies to the continuation of the Estate Agency Affairs Board. And basically what's happened there is the Property Practitioners Regulatory Authority has taken over from the Estate Agency Affairs Board. It provides for the appointment of the members of the board. And the reason why they've done that as well is now the board consists of 12 members. Because the definition has been so broad, and there's going to be a number of different professions that are being impacted as a result. So they're going to need different board members that represent the different property professions. It obviously provides for the transformation of the property practitioner sector through the property or transformation charter, at least. It provides for grants in that area, and how they're going to use that will still be determined. And one of the things that I like to touch on over the last couple of weeks is that it provides a lot for consumer protection. We've already seen a massive increase in consumer protection laws in South Africa, whether you're dealing with the Promotion of Access to Information Act, whether you're dealing with the POPI Act, or rather the Protection of Personal Information Act, whether you're dealing with the Consumer Protection Act that came into play in 2011. You're dealing with a lot of different pieces of legislation that deal with consumer protection. And this act most certainly provides for consumer protection. That's one of the most interesting and most apparent things that I've read in the legislation, as well as the regulations, is that consumer protection has been brought to the forefront.
Yeah, no, absolutely agree with you there. As the act started coming out, I did find that a lot of emphasis, one of the reasons why it was fast-tracked, as I understand it, again, this is completely opinion-based, was because of the transformation nature of it. The consumer protection element does come into play, but again, because the state agents had very similar rules and codes that govern them previously, only a few things here and there have changed insofar as the state agents are concerned. A lot of the stuff might have actually been intuitive. So you'll find that a lot of the larger, more established firms were already implementing a lot of what this act kind of requires. So full transparency, disclosure documents, which we'll touch on later. So for estate agents, it's not as big a jump, as I mentioned before, as one would imagine. But for the rest of the property practitioners, it certainly is. I think one of the biggest impact, or the intended biggest impact for this, was the transformation side. And I mean, this came across from stats released last year. I can't remember the exact numbers, but it was a dismal proportion of property practitioners, or back then estate agents, that were previously disadvantaged. So you still had a very high ratio of white males or females, or whatever the case might be. So this was something to try and promote that. And unfortunately, the EAB under the previous regime wasn't getting out enough initiatives to try and push this along, whereas this act actually provides, like Peter mentioned, for a fund to be established, how the fund is going to be applied, etc., etc. So that is definitely one of the biggest considerations insofar as purpose is concerned. Shilibo, I don't know if you want to touch on purpose, or, otherwise I'm going to maybe just move on to the specific definition.
No, you can move on. It's fine.
Awesome. Look, so I think Peter, you and I have already kind of touched on this quite substantially. I suppose for the benefit of the viewers here, a lot of people might be asking, especially considering that there was a podcast or a webinar a couple of weeks ago where the question of whether investors need to be like full status estate agents or property practitioners before they're actually allowed to buy property and Airbnb it out, or long-term investments, or things like property flipping, selling these things. So when I initially had read the act, I always understood that when you own the property and when you're dealing with the property, even if it's within the course of trade, that you don't need to be registered because it's your property, you're doing with it as you please. The definition does kind of touch on acting on another person's behalf, and that's one part of the definition that's quite clear, is acting on one person's behalf for gain. So I maintain, for all intents and purposes, that property investors, such as people flipping or buying multi-lets or holding them for long periods of time, and people buying an Airbnb out, shouldn't technically fall within the ambit of the act. Your thoughts?
Bruno, I'm in 100% agreement with you. When I read pieces of legislation like this, I always try to read it quite openly. But at the end of the day, you cannot be restrictive in the current practices in South Africa when it comes to things like property investment, flipping, when it comes to letting out your own Airbnb property. I believe that at the end of the day, we are obviously going to get directive on this. When I read the definition of property practitioner, it's not the first thing that climbed into my mind, that a individual property investor investing in his own properties, renting out his own properties, Airbnb-ing his own properties, flipping his own properties would fall in the definition of a property practitioner. It wouldn't make sense to me practically, because we're obviously going to touch on this later, but then that party would need to register through the Property Practitioners Regulatory Authority. They might need a BEE certificate, they might need a valid tax clearance, they might even need to go through the entire process of completing their PDEs. And at the end of the day, that is restrictive towards the current practices in South Africa in property investment. It wouldn't make sense. It wouldn't make sense that a piece of legislation comes out that tries to overhaul how an individual is supposed to do their own investment versus an industry that definitely needs more regulation and stricter regulation in a certain way. I do not think it would apply to that, Bruno. I'm in 100% agreement with you. Yes.
Yeah, that's perfect. So I think that's of great benefit to the viewers, because a lot of the people watching this and that are going to watch this are a bit panicked about that. I'm just to kind of throw a spanner in the works there, though. What are your views, for example, and I mean things like management companies? If you do tax structure to a point where you have a management trust or a management company, and that company is acquiring some sort of profit or charging a fee to the property holding company, in your view, do you agree that unfortunately the act would seem to apply?
Bruno, I don't like your question. Sorry. Yes, Bruno, I agree with you. It would seem that should a person be involved for remuneration or gain in the management of a property on behalf of another, that they would fall into the strict definition of a property practitioner. I also think, and I said this right at the beginning, I wish we could get a clear-cut directive on something like this. I've told a number of clients that they need to apply for exemptions in terms of the Act, in terms of Section 4, because that's a possibility as well, that you can actually go through to the PPRA and request an exemption on specific sections or specific provisions of the Act that wouldn't necessarily apply to you. I do believe, like you do, in that if you are involved in the administration, supervision, or management of a property on behalf of another for remuneration or gain, that it's very possible that you would fall under the auspices of this definition of a property practitioner. I would love to see more people communicating in this regard. I think we're all in the same boat when it comes to this. As a property investor myself, and possibly even later on looking at management in certain contexts, I would love to see a clear cut of who actually needs to be registered in this way and who doesn't need to be. I mean, you've already seen in terms of the Act, in terms of the definitions, that there are a number of exclusions regarding attorneys and candidate attorneys, etc., which makes complete sense because we already provided for in terms of the Legal Practices Act. But it would definitely make things a lot easier for me to answer this question if I had directive from the actual regulatory authority. I wish I could step in their shoes and just go yes or no.
Yeah.
But for the moment, I would say I am leaning towards your side of things, that management would possibly fall under this definition. Yes.
And I even had an interesting conversation with one of my attorneys yesterday, where he was asking the question on the fact that they actually refer to attorneys and not legal practitioners, and whether this excluded advocates who might be appointed as curators and charge a fee for it.
Wow.
Yeah. Yeah. Wow. So the problem is it's relevant. It might not be necessarily relevant in this forum, but it's relevant in general because we work with many curators who are advocates who have now asked this question, whether they included in the definition of attorneys.
Can I give my sort of, a bit of an opinion on this one?
Sure.
Please don't take it as if it's TPN Credit Bureau's opinion on this, but my opinion on this at the end of the day is that even the Act was drafted already in 2017. Or let's not say it was drafted in 2017. It was probably drafted around about 2014, 2015. It was promulgated in 2017. You've got certain sections of the definitions that refer to the Financial Services Act, which has already been repealed in the interim between this Act being promulgated and it becoming effective. So I think it sort of falls into that category, where they didn't necessarily change the definition of an attorney or a candidate attorney, because they didn't take into consideration that it should actually be a legal practitioner.
Sure.
So that would be my opinion. But once again, we can argue about that the entire evening. The only way that we'll actually know is through proper directive from the, or rather, Property Practitioners Regulatory Authority.
Are there any interesting insights on that opinion piece from CDH insofar as the developers are concerned? Again, not a TPN opinion, but maybe something that developers in the room can rest on, or like put some hope in.
Yeah, I think I sort of mentioned it in the first portion that I spoke about. It almost seems to me like it's a Consumer Protection Act argument. We had the Consumer Protection Act that came into play in 2011, and there were so many arguments regarding, should the CPA apply to lease agreements? Should it apply to sales? Because at the end of the day, we've got the Rental Housing Act that regulates this entire process. And as much as we take it that it currently applies through court decisions over the last 11 years or whatever it might be, that it would apply to the leasing scenario or the sales scenario specifically. With regards to the opinion piece, I think that property developers, because they are developing their own properties, I think there needs to be further provision when it comes to consumer protection, because I do believe it's a very good way of going about things, is consumer protection and how these things are supposed to be regulated, especially if they're regulated by different pieces of legislation. But then I think only certain portions of the Act should apply. Things like your mandatory disclosure form would be a good idea to have applied to individual developers, because then you would know that the property is in a certain condition. But the entire registration process and getting your FFCs and doing the entire rigmarole of writing PDEs, etc., it wouldn't make sense to me for an individual or a company that develops properties to fall under this Act's definition, even though technically, if you're looking at the definition, it would. Bruno, I wish I could tell you definitively yes, no, but I can't, unfortunately.
Look, this almost strikes me as a piece of like old tax legislation where there should probably be references to like connected persons, you know, that allows for certain things to take place that's not arm's length, and the Act wouldn't apply in those situations. I don't see anything in the Act really dealing with that. So that would be great. And then again, the same way that SARS issues directives on best practice, this is probably something that we're going to need them to do relatively soon, to say that they're more than happy to give certain exemptions on A, B, and C if you can show this, but provided you comply with D, that sort of thing. You know, just so the Act stays in force, there's no uncertainty, but at least we know what sort of exemptions to expect and how easy they are to actually acquire.
You're speaking my language, Bruno. I really hope for some clear-cut directives in the coming months that really speak to who needs to do what in terms of this piece of legislation. It would really make sense.
Bruno, yeah, I mean, speaking of exemptions, I'm also hoping so, because if you refer to certain sections within the Act, like section 55 and 54, and you're looking at those requirements, particularly relating to accounting records, keeping records, appointment of auditors, you know, some of the property practitioners might actually not even afford to appoint an auditor. I mean, there's a 1 year, they say, after year end, it's just actually section 55, where it requires you, after year end of your financial year, you need to actually have audited your financial within 6 months. And you cannot actually even deviate from that within that 6 months. Otherwise, you need to get the permission from the authority. I'm not sure if a fairly medium or small property practitioners can actually comply with such onerous requirements. So, like you said, we need some sort of guidelines on some of the exceptions like that are applicable. Because, for instance, it's a known fact that some companies actually are not required to be audited. Now you've got a spanner in the game to say certain property practitioners now needs to be audited while they are used of not being audited. That's extra 50K of auditing fee that eats into the margins of these guys. So yeah, I agree with you. We need some sort of guidance and to find a way of getting exemption. And
it's the business and trust account.
Yes. Yeah, exactly. So you need that, as long as you fall within that categories of definition. Hence, to say this definition is so generic in such a way that it casts the net wide enough that it catches everyone. But I mean, think about it. You're a fairly small estate agency in a corner of Joburg, and the next thing you're required to appoint auditors. Every year, the funny part is where every year you need to update the records of that particular auditor with the authority. That's extra admin person, by the way, at the office. The same process that you're going to have to do it, you might have to hire someone or outsource, which means additional cost to the service providers.
So it is fortunate. Sorry, Peter, I'm assuming you want to mention the exclusion or the application to be exempted from applying for FFC.
Bruno, you are reading my mind here. Go for it, please.
No, go for it, by all means.
Interestingly enough, in the transformation section in the Act, in terms of section 23, there's an exclusion that you can apply for if your turnover is less than 2.5 million rand, that you would not need an auditor to audit your trust account. So it's a pretty interesting provision and where it currently sits in the legislation, but there would be that exclusion that you can apply for, that you can have a qualified accountant to actually do so rather than an auditor. But I just wanted to chime in on that one.
So I mean, I suppose to Shirley Boy's point, it's still quite it's still onerous, either way you look at it. But at least, yeah, it
Most
might not
certainly.
have to be, an auditor. And also, just for the benefit of the viewers out there, there are also provisions regarding the exemption from having to apply for an FFC. And the reason for this is if people don't actually utilize trust accounts. So remember, attorneys have trust accounts because when we do conveyancing matters, we hold money in a central safe place, a kind of no man's land. And until the property is actually transferred, because it's a process, you don't want the purchaser to hang on to that money and then you potentially as a seller never receive it. So the attorneys are entrusted to hold that during this kind of limbo period and make sure that the money lands up in the right hands. So estate agents carry a very similar function with their trust accounts. They do this also with sales occasionally, although typically it's more attorneys than property practitioners. But with leasing agents, that's a big one because leasing agents typically hold deposits. But if you look at home inspectors like Marisha, for instance, she's got absolutely no need to have a trust account. So she would be able to apply in terms of that section to be exempted from it.
Excellent point, Bruno. Agreed.
Cool. So then maybe the next thing to discuss is the disqualifications. What it actually takes to become a property practitioner, what hurdles you need to jump through, and what hurdles there are that totally disqualify you from becoming a practitioner.
Thanks, Bruno. Good topic over here. Once again, we discussed this beforehand because as much as I like to give my opinion of legislation, it's something incredibly difficult because I've seen so many different disparaging opinions when it comes to qualifications and what's actually required.
Sure.
Sorry, go for it, Bruno.
No, I'm agreeing with you.
Okay. And what's actually required when it comes to your qualifications. So currently, to be a principal property practitioner, hear that, principal estate agent, you're needed to have an NQF4 and NQF5, obviously doing your logbooking and submitting that through to the Estate Agency Affairs Board. What I've seen and the amount of webinars I've watched on this now, including the private property webinar, as well as the webinar that the actual Property Practitioners Regulatory Authority had on this, it would seem as if they're doing away with the logbooking system is one of those things that I can say has been confirmed by the Property Practitioners Regulatory Authority. How I'm reading the regulations and the Act is that you would no longer need to qualify for an NQF4 and NQF5 to be a property practitioner. That's how I'm reading it. I've heard a number of people say that, and I've seen that on the property on the webinar that we had the other day, which would make it quite a lot simpler to become a person who can deal and manage and sell properties and rent out properties on behalf of another person. It would make a lot of sense to me. What is included in the regulations is that you need to do your pupillage, or rather be under the supervision of a registered property practitioner for a period of 6 months, and then write something they call a PDE, or a professional designation examination, which would set you up to be a property practitioner. Bruno, in my reading of the Act, I didn't see anything like a principal property practitioner. I only saw things like a property practitioner and a business property practitioner. Obviously, a business property practitioner being the entity, the PTY Limited, the closed corporation that they're trading out of, and a property practitioner being the individual natural person. So it would seem to me as if they are doing away with a number of their administrative protocols when it comes to the actual qualification that is required. However, in terms of you being a property practitioner, you would still need to do a CPD qualification every single year, whereby you'd need to do 12 modules over the 3-year period to maintain your Fidelity Fund certificate. That's basically meaning 4 CPD modules per year. But for qualifications from that front, I do think they are doing away with a lot of the administrative issues that we've seen previously with people being granted NQF4s and NQF5s. I mean, I know estate agents that have tried to go through this entire process and become a principal, and it's taken them 5 years. So perhaps it would lead to a transformation of the sector, as well as people becoming more inclined to be regulated by a piece of legislation, because the threshold is lessened as a result of this new piece of legislation.
Look, it'll definitely, and I mean, again, opinion, but it'll definitely increase the influx of estate agents, would definitely play a part for transformation. My worry when it comes to lowering entry barriers is the quality of education behind them. Obviously, I'd much rather punt and give more education and get highly qualified people out than lower the barrier and get anyone in. But I suppose another point to this, and maybe this is something that the authority should consider, is management of trust accounts, because even us as attorneys, you can't start your own practice without proper training on trust accounts. So there's a distinction between an attorney that's simply practicing as an attorney and an attorney wanting to start his own practice, because trust account money and the regulations behind it, and the amount of time you need to spend with the auditors to make sure that your things are in order, that's something special in its own. If you don't have that extra kind of qualification or that extra knowledge, it's virtually impossible to optimally run a trust account. Okay, cool. And then Shilly Boy, tell me, I think Peter dropped off. Oh, okay. So the Shilly Boy, this is actually the part that I wanted you in for. So one of the two disqualifications that they have here that deal with structuring, which is what Intergen does, is the tax certificate. So every tax clearance certificate, so every property practitioner, so this would include the juristic person and the natural person, must have a tax clearance certificate before they're basically registered as property practitioners. I've got my views on whether this is actually a viable rule, but let's for a second assume that it is, and maybe you can give your input on that. And then the BEE certificate, and they don't say necessarily BE affidavit, they say certificate. So that's also another little worry that we have for small enterprises that don't necessarily get certified, that simply complete an affidavit. What are your, sure, like go for it. What are the pitfalls?
Yeah, look, with regard to BE, I mean, maybe based on the previous best practice, where, especially in the tendering space, where at the beginning, they used to require a lot of BE certificate, and later on, affidavits also were considered to be acceptable. And government even end up creating some sort of a standard affidavit that people could use. Maybe it's something that might be one of the exceptions that later on, when this act is starting to be in practice, maybe through lobbying, some of people can end up saying, listen, from cash flow point of view, also, it might not be viable for specific property practitioners, like Peter mentioned earlier, about those ones with turnover of less than 2.5 million. Maybe something that might have to be considered. But then going back to issue of tax, I mean, at the end of the day, we all know that it's a civil right, or it's a legal obligation to start with. As long as you are any income, you need to be registered as a taxpayer. So I think that fundamentally it's something that we can actually bypass. However, I personally think, because if you look at this act, the development or the processes of coming up with act, various stakeholders tend to be engaged. And then I actually suspect that SARS being one of the key, or even for that matter, National Treasury, be one of the key stakeholders within the jurisdiction of fiscal policies, there must have been having some sort of a conversation with those two stakeholders. And you also need to understand one of the fundamental reasons why this act might actually include this, because you can see that the country has been going on a huge drive to actually having more tax collections. So I'm not surprised to see these sort of requirements being inserted within that. And I don't see how will even be possible that we will not get it. Maybe let's look at on individual side. I think for me, it's a matter of say, it's actually easier to comply, especially as an individual, because the SARS has created a system where it's actually supportive of individual to submit even their tax returns. Because one of the reasons why people will not have valid tax clearance certificate in most cases for individual is non-submissions of tax returns. That is just one of the key things. Why would you not? Because one of the things that I always say, even if you owe SARS, you can actually, provided they agree, enter into some sort of arrangement of paying whatever outstanding amount that you might be owing to SARS. Then as a result, with that, the end actually can find a way more likely giving you permission to get that valid tax clearance. So I think for me, it's about encouraging guys to say, yes, it might be something that you've got a certain emotions when you think of SARS, but try to be more proactive and actually submitting those tax returns. Then the requirements of tax certificate wouldn't be a burden actually, because it's something either way you should be doing as long as you're earning income.
So, so what you're saying is that non-compliance with tax legislation, in that you don't submit any returns, you ignore SARS, whatever the case is, that is going to get you in hot water. But if you actually even enter into a payment arrangement and you haven't fully paid, there is a possibility, we don't know for certain, but certainly a possibility that tax clearances would be issued to say it's okay, he's made a plan for the repayment of whatever tax is due.
You're totally correct. And I think let's even take a step back. SARS doesn't even just rush to, how do I put it? Doesn't rush to actually just get you to the position of, chasing outside. Basically, what they typically will do, they'll remind you, say, Shilly boy, your tax returns are not submitted. Can you please submit your tax returns? You understand? And I think maybe, and that's exactly why you're saying, this is where the likes of Intergen comes into play, because if you are too busy as a property practitioner, you don't have a capacity to go to SARS and actually submit your tax returns, or you're not technologically equipped where you can have your own e-filing, because for individual, for that matter, you can actually, it's free. You can register on e-filing and do your own tax returns, provided you've got all supporting documents with you. For that matter, you can even go to the branch, nearest branch. They can help you with submitting those tax returns. Or for that matter, if you feel that your tax returns are too complicated, then you can reach out to people like Intergen, where we assist you on those submissions of the tax returns. Like you said, yes, if you reach out and you, obviously, if they communicate with you and say, listen, Shilly boy, you haven't submitted tax returns, can you please submit your tax returns? At some point, they're going to have to issue the final final warning. Say, listen, we have been chasing you. They even call these days, they will pick up a call and call you, provided your records actually are up to date at SARS. So they'll call you and say, listen, we can see that, they're so lenient. Really, they are very proactive, because they will call you and say, listen, you've got outstanding tax return for the past 6 months. What's going on? Or for the past 2 years, 3 years, why are you not submitting tax return? Then if you keep ignoring that, no, you'll see an email with a huge penalty.
I get you. No, okay. No, that's actually really good. So there is hope. And I suppose for everyone that might fall within the scope of property practitioner, there's ways of doing it. It's just about, like pulling up your socks and actually going for it.
And I think, Bruno, maybe if I may steal time to say, listen, I think also it's a matter of familiarizing yourself as property investors or business people to say, when is the tax season? And the basics, just to know the basics, to say, when is the tax season? If I'm so-called professional taxpayer, especially if you are earning trade income. So you will more likely to be a what we call professional taxpayer, which means there are certain additional requirements that you need to comply with. For instance, if you are a professional taxpayer, every 6 months, you need to sort of submit what you call professional tax returns, right? So it's more like paying potential tax liability twice within a year of trading, year of assessment. So my view is that familiarize yourself with such kind of basic steps so that you know when you are required to submit what. Like for instance, on the 28th of Feb, the second professional tax payment is actually due before the end of 28th of Feb. So at least know those timelines, because the beauty is that those timelines don't really change. So it's only when the so-called tax season that tend to be extended, normally start from July to November. And then if they're lenient, they see that there's a huge backlog, they tend to extend it into December period. So if you just familiarize yourself with that, at least you'll know. You can even just diarize it and say, listen, end of August, as an individual, I need to have submitted my first professional tax payments because I'm a so-called property sourcing agent. I earn commission from brokerage. I earn another rental income of some sort. You understand? Then you know also that my second final professional tax payment needs to be due by the end of 28 February. Can you see that in that context, then you will actually be more aware of your timelines. I don't see why then you'll find yourself on a back foot. Unless your tax matters are more complex, then you need to reach out to the likes of us and we sit you down and say, this is the process. And of course, you have supporting documents. And Bruno, if I may also, one of the key things that I've seen where most people, whether it's a company or it's actually individual, they're lacking with submissions of the tax returns is lack of supporting documents. I cannot stress that enough because you need to keep your records. And I like the fact that actually in this PPA, they're actually requiring that you need to keep records for minimum 5 years, which is actually equivalent to what SARS will also say. Because SARS can come back later and say, listen, we're reopening the tax returns of 3 years ago or 4 years ago. We're suspecting some sort of something around that. So which means that should you not have those subordinate documents, can you see that you might end up actually not even having valid tax clearance and you're out of business. So my advice is that keep those records. They're actually even going to be required by this authority for minimum 5 years. They can call upon and say, we need so and so records, similar to what the Act is actually saying with SARS. SARS can also come back and say, we need the records of about 5 years back. So I actually like the fact that they actually aligned processes.
Sure. No, that's good. I see Peter's back on. Hey, Peter.
Hi, Bruno. Sorry about that. Everything went off. It was wonderful.
You're going to have an interesting evening ahead of you.
You can only laugh about things like this, but I do apologize.
So we've only got a couple of minutes left. Maybe if you just want to run us through something that a lot of people will eventually ask about, the mandatory disclosure forms, and I'll maybe just wrap up after that on the earning of commission, and then we can do the Q&As. Jay, does that sound good?
That's perfect, Bruno.
Cool.
Thanks, Bruno. Great idea. Okay, so mandatory disclosure forms is one of those things that is going to become more and more apparent, even if you're just a property investor. The individual property practitioner is going to request of you to complete a document called a mandatory disclosure form. This document sets out the condition of the property at the point in time when signing the mandate. So actually, prior to entering into a mandate, a property practitioner is required to have a mandatory disclosure form by the landlord or the seller of the property. This document must then also be attached to the lease agreement or the offer to purchase, and it must be signed by all the individual parties to the contract. We've taken this to mean the estate agent or the property practitioner, the tenant, as well as the landlord, or rather the seller, the purchaser, and the individual property practitioner. The interesting thing when it comes to this is that they've placed the liability not necessarily on the condition of the property, but to have that mandatory disclosure form on the individual property practitioner. And the property practitioner can be held liable should there not be a mandatory disclosure form if one is required in terms of the Act. Now, for an individual party, Bruno, like you said, we are saying things like an individual property investor renting out his own property or renting out his own property for Airbnb would not be required to have a mandatory disclosure form. But if you're using an estate agent, if you're using a property practitioner, that property practitioner needs to supply you with that actual document. That document is encapsulated in terms of the regulations. It's actually been drafted in the regulations as a template that can just be utilized. But that is one of the major things that I see for your network, for property investors, that they'll be requested to actually complete at a time with their dealings with the property practitioner. I actually think this is going to increase compliance. The reason being is that I'm sure, Bruno, you see this all the time, but property practitioners not signing mandates and not signing mandates with owners, I think it could actually be incorporated in the document as an annexure so that you have a scenario whereby all the parties are properly protected, not just for the consumer, but for the individual property practitioner as well as the landlord when it comes to these deals being transacted by these property practitioners. But that's about it. I mean, mandatory disclosure forms, it's not going to be required for an individual investor, but if you're using a PP property practitioner, you're going to be required to sign that document and fill out the actual condition of the property prior to renting or selling.
Sure. It's actually quite an intuitive clause, though, in the sense that, like I mentioned earlier, some of the larger estate agencies have already been utilizing it because it's good practice. So they don't want reputational harm from a seller that lies, and the estate agent ultimately gets blamed because there was an issue and the purchaser feels that the estate agent should have known. And another thing that people also need to realize is, at the end of the day, the seller completing this form and signing it doesn't change our common law position that if the seller intentionally hides something that they know about, they're not protected by footsteps. They're not protected at all. The purchaser does have recourse against the seller in those circumstances. So insofar as your relationship directly with the seller is concerned, this doesn't effectively change things because you would always have that recourse. This obviously brings now the estate agent to the picture and kind of requires the estate agent to themselves apply their minds. But that being said, also just another point or another thing I just wanted to mention is this does not necessarily require the seller to point out or discover things that he did not know of. It doesn't place an obligation on the seller to go get a home inspector to find every single defect and put it on the disclosure form. And although that probably should be a good practice from the purchaser side, the seller only need disclose what he actually knows to be a defect. You agree with that, Peter?
Most certainly. And even in the provisions, it says that the tenant or the prospective purchaser is not precluded from inspecting the property themselves. So it creates sort of like a latent obligation on that party to ensure that what they're buying is actually what they're supposed to be buying at the end of the day, in the condition that they're buying it.
Sure.
So it is not as far ranging as, like you said, that any sort of patent defect on a property or rather latent defect on a property that cannot be properly viewed at that point in time is just going to automatically come out.
Sure. Cool. And maybe then just on the last topic, I've discussed this previously, so I'm not going to go into a lot of detail, but I know the viewers normally ask this question. Earning of commission. So it's sourcing agents, guys on the ground trying to find properties and trying to wholesale it, as the Americans like to refer to it. Guys, bear in mind that in South Africa, the practice of acting on another's behalf and in any way facilitating the sale or purchase of a property basically encompasses a property practitioner. So either which way, you would have to register in terms of the Act. I have spoken to everyone about lesser things that they can do that might not take them to that definition, but the concept of wholesaling or property sourcing does typically require registration as a property practitioner. And the difference between the previous act and this act, and this is a big one. In terms of the previous act, even though it was unlawful to be paid a commission if you weren't registered as an estate agent, if you did ultimately receive the commission, no one could claim it back from you. In terms of this act, that position has now changed, meaning that if at any point after payment of commission to you, it's discovered that you weren't registered as a property practitioner, that amount can be claimed back from you. So that's also very important to realize. If you are in that sort of sphere, get yourself compliant. There's many ways of doing it. I've released countless videos explaining that process. Just make sure that you know that the red flag goes up and that you know the consequences if you don't comply.
100% in agreement, Bruno.
Great stuff. Bruno, thank you, Peter. Thank you, Shirley Boy and Bruno. That was very informative. And ladies and gents, we're going to have a Q&A session shortly. I see there are quite a few questions in the Q&A tab. So that is awesome. Looking forward to that. Some very interesting questions coming through there. Now, ladies and gents, please go to our website. This will also come into your inbox, sapropertynetwork.com. Click on online events, click on add the event to your calendar, and then you will be reminded about any events coming up through SAP. And now, just quickly, I did mention earlier that we are going back to in-person events, and this is really exciting. We've got our first event in Cape Town on the 23rd of February. So everyone from Cape Town, please be ready and be there on the 23rd. We got PE on the 2nd of March. Really looking forward to that. Everyone from East London, please be here as well. And then on the 11th of March in KZN in Durban. So I'm sure all of you are very excited about that. Then 2 events coming up on the 5th of March. We've got Forex and crypto trading for property investors. That's pretty exciting. So that is on the 5th of March from 9 to 12 o'clock with Lewis Crompton from the UK. So very interesting workshop. 3 hours with Lewis. He's a very skillful investor from the UK. And then Andrew Walker will be hosting the Wealth Builder Workshop, which would be in person, Joburg, Durban, and Cape Town. And you can get the dates. Just go onto our website, or you can email, as you see there, support@sapropertynetwork.com to get any further information. So we're going to get straight on to the Q&A now, ladies and gents. And I unfortunately got kicked off, so I can see the last 6 questions. So I'm just going to start with Diane Smith. And Dave, if you can maybe help me with the first few questions, because I don't know which ones I missed. I'll start with Diane. She says, I'm a sole proprietor, and we've always had to have a CA submitting my trust. And the EAAB has added the My Business account as well. Bruno, can you make sense of that question?
Let me read it.
Diane Smith sent at 6:36.
I don't. Sorry, Dave's message just got in the way of the question there. 6:36. I'm a sole proprietor, and we have always had to have a CA, which is normally a chartered accountant, but you know, on the same level as the auditor, submitting my trust. I'm assuming trust audits, and the EAAB has added My Business account as well. Look, the only thing I can understand from this, I might stand to be corrected, Diane, but what I'd mentioned to Shirley Boy is the fact that it's the trust account and the business account that the new act requires to be audited. So now it's both accounts. So unless you fall within the exceptions that Peter mentioned, so under a certain threshold, yeah, that seems to be the case. Agreed?
Agreed.
Cool.
Great stuff. Thanks, Bruno. Peter, maybe one for you. So technically, a private landlord holding a deposit will need to register as a PPE, or sorry, as a PP.
Must I freak all of your people out and say, or your network out and say, yes? No, please don't. Please do not register as a property practitioner. It's not required. You're an individual landlord renting out your own property. please don't do so. Don't go do your PDEs. Don't go do any of your CPD models. You're a private individual in the ordinary course of business, renting out your own property. Please don't register.
Great stuff. Thank you for that, Peter. And then Jaco Roots again asked, in terms of records, does it need to be the original tax invoice, or can we keep it electronically? Shirley boy?
Yes. Hi, Jade.
Shirley boy,
If you don't mind.
Did you hear the question, Shirley boy?
Yes. Are you referring to the one way saying about the supporting documents, whether they have to be original or then they can be electric, what do you call, saved in a soft copy?
Correct.
Yes, listen, you remember when you're doing the submissions of the supporting documents, so you ordinarily not gonna submit those documents when you're doing tax returns. However, you need to keep those documents, sure SARS actually audit you. So yes, you can digitally save them, and SARS typically will accept that should they request such kind of supporting documents.
Okay, perfect. Thanks, Shirley boy. Then Maimuna, I'm hoping I'm saying that correct. I've completed my NQF5 and await my results and certificate. Does this just fall away? Will it mean nothing now? I think, as you guys mentioned, it might be quite frustrating if you had to do your logbook and your NQF and all of a sudden you don't need to do it, eh? So I'm not sure who wants to take that one.
Bruno, I don't mind taking this one.
Yeah, go for it.
As a sort of joke, I heard on the private property webinar that they held, they called it an estate agent and an estate agent light. So yeah, it's an interesting concept, this one. But no, please don't carry on as is until we get directives. I don't want any of you to stop your processes, stop what you've been doing, stop the hard work that you've been putting in over all these years to try and get registered. Please carry on as is, carry on with your NQFs, carry on with your NQF5s. Until we get further directive, I think it's very important that you go about, I hate this term, business as usual. You need to do that. You need to protect yourself. I mean, yes, it's a new piece of legislation, but if there is changes and further directives, SAPN will obviously let you know about how this is going to affect you as a property practitioner. But for the moment, please carry on as is.
Sure. Agreed.
Great stuff. Thanks, Peter. Jaco's got another one. Jaco's very active there in Belgium this evening, but that's great. Thanks for that, Jaco. From what I've read, sole mandate will no longer apply on new developments to allow smaller players a foot in the door. Did I read this correctly?
So yeah, pretty much. There's it's almost anti-competitive behavior. So there's a whole bunch of provisions that deal with unfair practices. And if you look at it from the transformation perspective, it's exactly because of that. You have your larger estate agencies, whatever demographic ownership they might have, taking a monopoly over some of the larger developments, and the smaller players not getting their foot in the door. So there's a whole bunch of things about unfair practices on appointing only one agent, having an agreement with agencies where money gets paid back, having like rights of first refusal. There's a whole range of big no-nos that the Act has, even with conveyances. In the past, it was always unlawful for a conveyancer to give a kickback to an estate agent. Now it's unlawful for the estate agent to receive a kickback from a conveyancer. So now both sides of it are unlawful. So a lot of unfair practices have come into play there.
Bruno, just a quick question. Me being an estate agent, does kickback mean a monetary amount? Yeah. And what does it mean, a gift? So you got a bottle of wine?
No, it's any sort of, what's the best way to describe it? And not incentive, but yeah, so it doesn't have to be monetary in nature. It can be in kind. So okay. Cases where attorneys have taken estate agents on holidays or bought them things. There's a very fine line between what one would consider marketing cost or some sort of cooperation cost to be able to facilitate more deals, and then there's simply thank you for the conveyancing, here's some money back, or here's something in kind for the conveyancing that you gave me. But yeah, there's a lot of case law on this.
Okay, very interesting. Okay, then Jonathan says, I might be slow, but just to clarify, if we are buying and renting out property as a company, do we need to register? Does this change if we buy as a company and get another company to manage on our properties? I know we did touch on that, but just quickly, Bruno, if you just want to summarize the answer for that.
So no, you don't have to register if you're buying properties and just renting them out or selling them or flipping them or whatever the case is. Yes, potentially you might have to register as a management company if you have some sort of SPV somewhere along the line that receives the rentals and charges a fee for the said management, because the management of a property is by the definition of the Act the job of a property practitioner.
Jade, if I may come in, Bruno, just a follow-up question. What happens if, there's a lot of exceptions, especially when it comes to group tax and group transactions. What happens if that particular property management company is owned by a holding company that they are all identically owned by one ultimate beneficial owner? So will that maybe be one of those Peters is hoping that there'll be exceptions that such property management company wouldn't then needs to be compliant with the new Act?
So, I mean, that's why I even mentioned I would love to see more in the Act regarding connected persons, because then you could actually look at, arm's length transactions and things that are too close, intergroup dealings that you could actually exclude from the ambit of the Act. Peter, you're going to, I know you also have an opinion on this.
Bruno, I wanted to say this is your question. I don't want to answer. So yeah, the difficulty behind this is just exactly what Bruno mentioned, is that there isn't this whole portion of connected persons or subsidiaries or people that are excluded as a result of their connection by shareholding, by directorships, etc. So yeah, the legal interpretation would be any person that receives remuneration or commission as a result of the management of that. So you could probably, or possibly, let's not say probably, let's say possibly structure it in a certain way that there isn't a fee or a fund or anything that is coming across as a result of that management, possibly. But this is something that's going to have to be cleared up through the PPRA, unfortunately.
Great stuff. Thank you, guys. And then we get to, is it Sheree? I think it's Sheree. She says, also state agents sometimes have to pay an estate to be allowed to sign mandates and sell in that particular estate. If I understand correctly, the estates are no longer allowed to withhold us from selling if we have not paid that private right. Have you got experience with that, Peter or Bruno?
I do. Bruno, you could perhaps help me right here in terms of the new Act and the regulations. I haven't really seen anything specific when it comes to an estate or a body corporate. There was a directive put out by the Estate Agency Affairs Board, I think about 2 years or 3 years ago, saying that any practice that excludes a party for them having to pay a charge for, let's call it, not activation, accreditation, that is, accreditation on selling or renting properties in the BC or HOA is completely incorrect. They overturned that directive, and what they included in that directive is to say that if it is something, a fee that is required for things like access codes, access tags, all of the administration expenses and fees that come in as a result of the person needing access or to be able to sell would be correct. But a charge purely for accreditation is completely wrong. You definitely can't do that. I mean, you can't charge 20,000 Rand and not have a specific reason for charging that 20,000 Rand, similar to what you've got in rental scenarios with damages. I mean, you can't just charge what you want. You need proof of the actual factual expenditure that the person is going through. So Bruno, perhaps you've read something in the Act and regulations that differs from that, but I still believe that that directive from the Estate Agency Affairs Board would still carry weight on that.
I'm looking at it briefly. I think it's effectively being codified. So Regulation 35 under undesirable business practice, pursuant to the provisions that the following business practices are prohibited. Any arrangement in terms of which any party or person directly or indirectly controls or manages any property development, including any homeowner association, receives money or any other reward in exchange for a benefit, advantage, or other form of preferential treatment in respect of the marketing of properties in such property development. This speaks of development, but if memory serves me correct, one of the articles that I read extended it to any complex, because this does speak about the actual management of the complex. Yeah, so I would say, just reading this briefly, it wouldn't allow. You're right. If there is a specific fee for reasonable disbursement or some kind of admin charge, that would probably be permissible. This speaks more of charging a fee just for the sake of charging a fee to be allowed to sell within the estate. I believe that that's not allowed.
Yeah, thanks, Bruno. I agree with you. How you've just read it out now also says that it's for some form of benefit. Or a beneficial, use the term beneficial in that regard. So you obviously can't just say agency X can only rent out or only sell at this complex or HOA or development. So yeah, 100% in agreement with you. Thank you for that very quick research.
Nice.
Good stuff, guys. Last two questions. If property was bought in a CC trust or PTY, would the representative have to register as a property practitioner? And then just following on from that, that's the first question. The second question is, what if you're a group of investors investing together and not an individual? Would you still say they are exempt?
I say that they wouldn't have to register. The entity in itself is buying and selling properties. So you as a representative are an officer of that company. All companies need someone to represent them. So arguably not. Trust's a funny one, because I did see in the Act that it does speak of a trust where the person running the trust, that one of the trustees is actually being paid a fee to manage on behalf of the beneficiaries. So with the trust, I would say we need to look at it separately and try to figure out what the arrangement is. If it's almost like a trustee that gets hired as a property manager on behalf of the trust to benefit the beneficiaries. But with companies, that typically wouldn't be the case, even if it's a group of investors, unless one of them is being paid specifically to manage. And even in that case, if they're all in a company and they're all shareholders, I would say that they wouldn't have to register. Peter, I don't know if you agree with the trust company division or.
Bruno, I agree 100% with you. I read the same provisions regarding trusts and trustees. So no, you said it perfectly.
Great stuff, guys. Well, thank you so much. I know that was very informative to our members this evening. Bruno, Shilly Boy, Peter, thank you for your time. Really appreciate it.
Oh, thanks so much, guys.
Jade, thank you, guys. Thank you, Peter.
And your pleasure, Jade. Thank you very much.
Ladies and gents, if you have a look in the chat box, you will see Dave posted a link over there to the frequently asked questions. That's a TPN Property Practitioners Act frequently asked questions. That's quite a mouthful, but do go click on that because it's going to be very informative. It's going to be a nice summary of what we spoke about this evening. So go and download that. Then please complete your feedback form. Dave will post that in the chat box for us. Very important for us, ladies and gents, to get your feedback so we can always better our service to you as our members and investors. Please go leave us a Google review. If I can ask you, please do that. It really just helps us gain traction and just show people that they should be joining the SA Property Investors Network. Dave says he has also emailed that link to you guys. If you're on our database, you will be receiving that link. Follow us on Facebook if you haven't already. some very interesting questions on a daily basis being asked on our Facebook page, and our coaches are there to answer those questions. Okay. So, ladies and gents, almost at the end of the evening, well, basically we are. We said thanks to our expert guests. I would like to thank you. I'd like to thank all our sponsors and our associates for being with us this evening. Ladies and gents, have a great rest of the evening. It's been an honor to host the first content webinar of 2022. Looking forward to seeing you in person very, very soon. Have a great evening. Cheers.